Ready for reading and start. The validity of order granted by the learned trial court is under challenge at the hands of the plaintiff petitioner, hereinafter referred to as the petitioner stop. It is wide that order that the learned trial court allowed a plea filed by the respondent defendant for amendment of the written statement to take up a plea which is extracted hereunder stop. The High Court, while exercising its jurisdiction under Article 2 to 7 of the Constitution, has set aside the concurrent findings of facts of the courts below and observed that where the specific performance of contract in respect of immovable property has been granted, the sale price given in the transfer deed is to be accepted by the registering authority stop. I have heard the learned counsel for the petitioner and have perused the record stop. It appears that during the pendency of the suit for arrears of rent, the property in question was sold, but the suit was decreed ex parte because of the fact that the defense of the petitioner was struck off and that has become final up to the High Court stop. The petitioner filed a revision standing all these facts and filed an application under Rule 17 CPC for amendment in the written statement stop. The revisional court rejected the application on the ground that as the defense of the petitioner has already been struck off and unless and until that order is set aside, the amendment in the written statement cannot be allowed as the suit has already been decreed stop. The contention of the petitioner that this fact was concealed by the plaintiff respondent that has sold the property during the pendency of the proceeding stop. The petitioners herein are the original defendants in FIR filed by the plaintiff for partition and separate possession of the agricultural lands and the house property stop. The petitioners herein filed written statement and resisted the suit claim stop. According to the petitioners, who are the original defendants, plaintiff has got no concern with the husband of defendant stop. It is specifically averred that the plaintiff was not the wife of said person, and as such there is no question of consideration of the joint family stop. By this revision petition under section 397 read with section of the Criminal Procedure Code, Mr. Singh has challenged order passed by the additional sessions judge in criminal revision dismissing the complaint of the petitioner complainant stop. It was further pleaded that instead of accepting his request to return to her matrimonial home, the appellant and her family members misbehaved with him and refused to send her stop.